In Florida, the law is clear. Every person has the right to inspect or copy public records. It's written directly into the state constitution. But what happens when a government agency says, yes, we have the records you want, and no, we won't give them to you until you pay? That's exactly the question at the center of a real legal battle in Citrus County, Florida, and the answer the court gave may surprise you. On January 4th, 2026, a Citrus County resident named Michael Novich submitted a public records request to the Citrus County Sheriff's Office. He wanted 16 categories of records tied to a specific incident, a call for service from June 10th, 2025. He asked for computer-aided dispatch logs, known as CAD records, and calls for service reports. He was explicit. Give me the no-cost records first. Before charging me anything, give me an itemized estimate. 9 days later, on January 13th, Novich didn't receive any records. He received an invoice. The sheriff's office acknowledged that they had the documents. They acknowledged no exemption prevented disclosure of the non-exempt portions, but they refused to produce a single line of those records without payment. No anticipated production date, no itemized breakdown that complied with Florida law, just a bill. Over the next several weeks, Novich pushed back. He asked the sheriff's office to identify the specific statutory exemptions they were relying on. They responded that the records contained not public information, but cited no exemption. He asked again. On January 21st, they confirmed they would not produce any portion of the records until the invoice was paid. Not a partial release, not the exempt text, nothing. The standoff continued through January 26th with the same answer every time. Here's where the case gets interesting. On January 12th, just 8 days after his first request, Novich filed a second separate public records request. This one asked for CAD logs related to complaints involving a specific deputy. On January 29th, the sheriff's office produced those CAD logs, fully redacted at no cost, no invoice, no delay. The same type of record, the same agency, two completely different outcomes. Novich argued this proved the fee wasn't about the law, it was about the specific request. Novich filed suit in the 5th Judicial Circuit of Citrus County, Florida, under Section 119.11 of the Florida statutes, the provision that requires courts to give public records cases priority and set an immediate hearing. He argued that the sheriff's refusal to produce even the non-exempt portions of the records without citing a valid exemption was an unlawful refusal under the Florida Public Records Act and the state constitution. He asked the court to compel immediate production. The sheriff's legal team filed a motion to dismiss. Their argument was precise. Under Section 119.07, 4D of the Florida statutes, when a public records request requires extensive clerical or supervisory assistance, even as little as 15 minutes of staff time, the agency is legally permitted to charge a special service fee. And critically, Florida law allows an agency to condition the release of records on payment of that fee. They weren't refusing, they were waiting for payment. That's a legal difference. The sheriff's team made a second key argument. The CAD records weren't just partially private, they were intertwined. To produce the non-exempt portions, the staff member had to review every line, identify what was confidential under Florida statutes 365.171, and redact it. There was no shortcut. The act of producing the public information required the labor of separating it from the private information. That labor, they argued, is exactly what the law allows them to charge for. On June 9th, 2026, Circuit Judge Christy Heelis issued her ruling. The court sided with the sheriff. The judge found that conditioning production on payment of a lawful fee is not a refusal under Chapter 119, because the records contained exempt information that had to be redacted before any portion could be released. The clerical cost was legally justified. Novich's petition was dismissed with prejudice. That means it's over. He cannot refile. This was his third attempt, and the court found that no version of the facts he presented could support a valid claim. The case didn't end with dismissal. The sheriff's legal team also asked the court to award attorney's fees, arguing that Novich's lawsuit was filed for a frivolous purpose. Under Florida law, if a court finds a public records lawsuit was brought improperly, the agency can recover its legal costs from the person who filed. The court reserved jurisdiction to decide that question. It hasn't been resolved yet, but the warning is clear. Filing a public records lawsuit that the court finds baseless can cost you more than just the filing fee. So what does this case actually mean? Florida's Public Records Act is one of the strongest transparency laws in the country. But this ruling confirms something important. The right to access records is not the same as the right to have them prepared for free. When records require significant staff time to review and redact, agencies can charge for that work. And they can hold the records until you pay. If you're planning to file a public records request, especially for complex documents like catalogs, be prepared for a fee. Ask for an itemized estimate. Know the law before you file a lawsuit, and understand the difference between a refusal and a condition. The Florida sunshine is supposed to shine on all public records, and it does, but sometimes you have to pay for the window to be cleaned first. Michael Novich's case is a reminder that transparency is a constitutional right in Florida, but navigating that right requires understanding the law in full. The records exist, the public has a right to them. The question is always at what cost and under what conditions. Know your rights, know the rules, and if you decide to go to court, make sure your case can survive 3 attempts. Have you ever fought for access to public records? Have you run into a wall? Fees, delays, exemptions that didn't add up? We want to hear from you. Every story like this one matters. It's how the public learns where the system works and where it doesn't. Reach out and tell us your story. Drop it in the comments, send us a message, or share this video with someone who needs to see it. Your experience could be the next case that changes how we all understand the right to know. Don't forget to like, subscribe, and share. Join the private group to get the receipts and private training. Yes, we will teach you the methods used to expose these criminals and to hold them accountable. Hit the support button on my profile and bring your questions.